this session. And I think we can start the presentation so that it won't be on delay. And our work package leader, Vasiliki Kaludimou from Brasiford, will open the session.
Thank you, Alicia. Ladies and gentlemen, good afternoon. Welcome to another awareness-raising webinar by the widerAdvance facility, an EU-funded project that provides services on dissemination and exploitation for results produced out of widening actions. Today's webinar is about IP protection and management. As Alicia said, I'm Vasiliki Kalodimou. I represent the Praxi network of the Foundation for Research and Technology, HELLAS, which is responsible for outreach and community building. In few minutes, I will give the floor to our two speakers representing two implementing partners of widerAdvance facility, Ms. Gabriela Lovaz, the Managing Director of Europa Media from Hungary, and Ms. Alicia Voto, the Scientific Researcher and Group Head of IPNA CSIC. Today's menu is very rich. We address in the first part the IP fundamentals and IP intellectual property in Horizon Europe. We will start by acquainting you with what is a result and how it is linked to intellectual protection management. The colleagues will share information about ownership of results, background, foreground, consortium agreement, obligations relating to exploitation and dissemination, and some common mistakes out of observations. Now, we will have a coffee break for around 10 minutes or a little bit more, depending on how the time is at that moment. And then we return with how is IP protection in practice? Should we go for patent or a trade secret? How do we search for novelty, timing issues, cost considerations, the role of technology transfer offices? And then we go and we address other aspects, again, with relation to the IP management in practice, but more on the access of resources, like setting up an IP management process, how to turn the IP that we have protected or managed into impact, as well as European Commission resources offered in this direction. Of course, we will close with a Mentimeter exercise and the wrap up. Before I give the floor to our first speaker, Gabriela, I would like to present a few words about the widerAdvance facility. I know that some of you are already receiving services from the facility, some of you not yet. So we would like to present the facility to those of you who are not yet familiar with this project. So the widerAdvance facility is an EU project that will last until the end of 2028. It has been funded under the widera work program with the aim to offer exploitation and dissemination services to organizations which are beneficiaries of widening actions. We believe that by doing so, widening countries and outermost regions will be empowered to leverage the impact of their results already generating in widening actions and beyond, sustain progress and amplify their role into the European innovation landscape. As we said, the target group of the widerAdvance facility are not single projects, are organizations who have benefited in the past or are benefiting currently from widening actions. These can be closed or running, namely under Horizon 2020 or Horizon Europe, and who have implemented these actions either as partner or coordinator or even both. The key is to have some results from these actions, or even some results from actions which that organizations won after the initial widening action. In the facility is accessible by both research teams who are responsible for those results, as well as for the research management and administrators. As you will see in the later slides, the services are offered upon application. Namely, an organization will have to submit a very simple application to list some basic results. How do you identify results? Definitely, our speakers will tell us more about this. But after you apply to the facility, and I assure you the application process is very intuitive, a service journey begins. A very rich one consisting of a variety of services. First of all, you will have the right to participate to the Dissemination Exploitation Academy, where through three modular workshops, out of which the one will be on site, research teams and RMAs will be able to be more familiar with basic terminology on dissemination and exploitation, as well as to apply widely accepted methodology to their exploitable results, following instruction and guidance of the experts on an individual basis. Furthermore, participants will be familiarized with, for example, with other concepts like unique value proposition, and learn how to produce sustainability and exploitation strategy for each result they will receive service from the facility. And then one-to-one services follow, such as support with intangible assets, namely IP, intellectual property, with two basic routes, either strategies or negotiations with potential interested parties. Then selected results, key exploitable results, will receive support with standardization, and also key exploitable results that are a bit more mature will receive a service preparation to match with third parties, where experts will coach the beneficiaries to produce meaningful pitching decks and really teach them how to communicate, to constructively communicate better messages for different stakeholders. Also, these services are complemented by webinars, training webinars, which are restricted to service beneficiaries, as well as more open general awareness raising, such as this one. Furthermore, the project organizes dedicated matchmaking events on a regional basis, which aim to showcase the teams having produced results and to connect them with early adopters and end users for their key exploitable results. Last, we organize study visits to other research-based excellent organizations in widening countries. We offer coaching on synergies, which is that each participant has the right to receive mutual advice on follow-up funding, mainly from national, regional source, even Horizon Europe sources. Now, So as you understand, this is a service journey, okay, where it begins with the application, then you are contacted via our experts. There is a reiteration process so that the experts and you can have the same understanding of the results to be serviced by the facility. You will receive then your unique service delivery plan indicating all the services that you will receive during the facility. As we said, that this is enabled through an application process. And before we get to the application process, just for you to know that our facility has been very active in providing webinars in dissemination and exploitation. By visiting widerAdvance.eu, you can see all the past webinars and access presentations and recordings. The next trainings in the pipeline restricted to service beneficiaries are, for example, on June 23rd, EU trademarks and design. This is applicable to you, which are receiving already services from the facility, and there are more to come. Now, we said that the application is important for you to access to untap this service journey. Our upcoming cutoff is on the 31st of July. Actually, the widerAdvance facility has an open call until its end of the project, but we have intermediate collection dates. So one of the intermediate collection date is at the end of July, and the next one will be 3 months after the end of July. Those of you who are not yet receiving services, we definitely look forward to hearing from you, as well as to receive your application. If you so decide, please don't hesitate to reach out to us for assistance. In the widerAdvance facility, there's a dedicated section for contact point for your country, as well as ambassadors that can really that can really acquaint you with the facility or lead you to the right contact person. So if all else fails, just write to us info@widerAdvance.eu. So that was all from my part. Thank you very much. We look forward to welcome you to other services of the facility, and we hope you enjoy today's webinar. Now, I would like to give the floor to Gabriela Lovage, Managing Director of Europa Media, our first speaker for today. Gabriela, welcome.
Thank you very much, Vasiliki, and welcome also on my side, everyone, to this webinar. Let me share the screen. If in case you have any questions, I can also give you the floor. Just please raise your hand, and then of course you can ask the questions out loud, or also you can put it in the chat just in case. I will have in front of me also the list of participants where I see any reactions and also the chat itself. All right, so as Vasiliki said, I'm the Managing Director of Europa Media Nonprofit, the partner from Hungary within the widerAdvance facility, and we are supporting Hungarian institutions as much as we can in the application process. But also we are supporting the coordinator in the dissemination, communication, and exploitation efforts. So Europa Media has been putting together these training courses related to the research and innovation funding and other kind of actually EU funding since 2004. So we have quite a few years experience also training participants, of course, on all of these issues, but also we are writing our own proposals and managing our own projects. And that experience is shared also on an everyday basis in terms of training courses and also consultancy activities. So that's more or less about me. I have been doing this for a while. My first proposal was actually done during my university studies. That was not yesterday. And hope I can tell you a lot of things today about IP fundamentals just generally, of course, what is a result, what is IP, as Vasiliki said, but also then potentially, of course, how you take more practical, of course, management exercise when your project is funded. So we will go through, of course, from the very beginning till the more practical issues. I will share you a few concepts. What is innovation management, background, results, what is ownership, of course, what the European Commission means under exploitation, and also we will cover a little bit the new concept, valorisation itself. Then really shortly, we will cover the grant agreement and the consortium agreement. What, of course, are the legal considerations for the IP protection and management, and then some of the mistakes avoided also to finish. And then hopefully I should be finishing by 3 o'clock with this first presentation. So let's see as a starting point. Whenever you put together a proposal, of course, then you have an idea. That idea, of course, could have a lot of really interesting benefits for the scientific community, for the geographical region, for different interesting, of course, markets and industries. But at that stage, of course, you just have an idea and you plan, of course, to put together results that will be beneficial, of course, for all of these target groups. Now, when the proposal is written, you have innovation potential, right? You have to introduce this innovation potential. Like what is, of course, then what you can achieve? How can you go beyond, of course, the state of the art? What kind of novelty elements you can introduce, of course, with this project? So all of those results, of course, your ideas will have an innovation potential. Now, innovation from Horizon Europe perspective, right? It means that this is an outcome that will be used for the benefit of the different target groups, geographical region, scientific community, industry, and so on. And the keyword here is the use. So it is nice, of course, to have results that you protect, which is then the IP, of course, management part, protecting, of course, the intellectual property. But that's not enough, of course, to achieve innovation. You need to make sure that that result will be used after the protection. That comes, of course, with exploitation strategies and plans. And all of that together, basically, in order to make sure that during the project implementation, you will be putting together the results that your specific end users and target groups will be using, will be benefiting from. All of that is called innovation management. In order to be successful with your plans, of course, that you put into the proposal, those exploitation plans, of course, those IP protection measures that you included into the proposal, you need, of course, kind of a full activity all around, of course, your results. And we will cover what are the basic IP management stacks also in the next presentation, but I just want you to kind of remember that potentially it's not enough, of course, to think about what kind of basic IP we have and how potentially, of course, we protect it, but also all around, of course, we need to understand the environment. We need to understand, of course, the market. We need to understand potentially, of course, the state of the art on scientific level, technological level, policy level as well, in order to make sure that also throughout the implementation, we'll be still delivering, of course, what is needed. Right? The whole perspective, of course, behind our idea that we would like to solve a challenge, we would like to meet a specific need. In order to understand that, of course, we need to have a good knowledge, we need to talk to the stakeholders, and we need to continuously doing that also during the implementation. So innovation management comes with quite a few kind of typical tasks, which is, first of all, understanding, of course, the opportunities and the needs, trying to put together, of course, a strategic approach overall behind all of the results that the project is putting together, not just one, not just two, but all of those. Then we are trying, of course, during the implementation to capture all of the results and, of course, potentially even create new ideas based on those results. But the main point is to capture and see what is the value, what is the potential, and what kind of innovation capacity of the consortium could be used, of course, to successfully exploit it. We continue throughout the implementation to monitor the market, the IP, the technology landscape. We try, of course, to put together a plan to meet all of the objectives and the market needs, talking to the stakeholders all the time, of course, on a regular basis. And then, of course, ensuring that we are trying to put together management procedures and structures in order to use all of that innovation capacity that we have in order to meet, of course, the full innovation potential. So that's kind of the starting point. On the slide, you also see how the European Commission defines innovation management, but that is basically all what I said. But again, we need to make sure that it's not just that we have results, and it's just that we have a plan, but we also then, of course, ensure that there's a validation and there's an adoption. And that is, of course, happening potentially not necessarily only within the project duration, but also very much after the end of the project. Sometimes innovation is happening, the real one, of course, that the Commission is interested in after the end of the project, and it's not a problem at all. It's not always true, of course, that we'll be developing the result, which is readily available, of course, for the end users to use. In order, again, to go back to the very beginning, we need to make sure, of course, that we understand the needs, because we are developing results to be used. And the European Commission wants us to consider at least 4 different groups of stakeholders who will potentially use our results. The research community, of course, with the academic and the research organizations, industry, innovators, the market, chambers of commerces, and so on. Then, of course, we have the civil society with the non-governmental organizations and the civil society organizations, citizen initiatives, and so on. And then, of course, we have the decision makers and the policy makers. So the European Commission, of course, has put together already a list of results that traditionally, of course, goes to this or that specific community. Our job when we put together the proposal is to make sure that we come up, of course, with all of these results, and we are trying to meet the needs of all of these key stakeholders. Because while the group says policymakers, it's you who's defining if you target the local, the regional, the national, the European, the global level, with what kind of result, and what is exactly, of course, that need, what is exactly, of course, the challenge that you are trying, of course, to solve and meet with that specific result. So that is, of course, the planning phase. This is up to us. But, right, all of that, of course, if we put together a result that is normally connected with intellectual property, right? Our human brain, of course, will be putting together a lot of useful things. Would it be models? Would it be, of course, any kind of interesting scientific data, product services, business models, any design, policy recommendations? All of these, of course, will come out from the project with the help, of course, of the knowledge of the people within. Now, intellectual property management is extremely important. Also within the proposal, of course, you will be sharing plans with the evaluators how you want to protect the results that you develop. But more importantly, it's just part of the whole innovation management process. And nowadays, we should also talk about the so-called asset management, which is broader than just protecting, focusing on the protection of the result. But it's also, of course, trying to put together the kind of the optimal environment in order for that result, again, to get validated and get adopted. So really, of course, you remember the innovation is about the use, right? The keyword, of course, there, that can only generate the benefits if it is used. So that's kind of the overall picture as a starting point. And of course, in the proposal, we normally think about these classic protection measures. So of course, behind the intellectual property, we can form certain legal rights, right? Protection measures. And of course, they normally have a different purpose, and they normally have, of course, a different process as well. And we need to understand the basics behind this. As a starting point, just really let's quickly go through. The patent is for technologies, right? Technological inventions. Now, this is something that even could be achieving a 20-year protection period. It is normally, of course, registered for specific regions. And there's a really strict, of course, novelty element examination by the specific patent offices. So while you apply, of course, there is an examination period as well. It can take quite some time, but afterwards you are better protected. And of course, for a longer period with a wider kind of geographical region. Utility model is easier to get. It's normally covering a specific country. There is, of course, an application process, but it's quick because there's no novelty element specific, kind of analysis. In some cases there is, but most of the cases there is not. And that's why it takes less time. It is less expensive. But again, it's for a shorter period that the protection is offered. And also, of course, the protection is not that wide, so to say, as the patent is. Then the copyright is, I suppose, the easiest. Everyone knows that, right? It is automatic. You do not need to register anything, of course. What you need to do is to attach, of course, to that copyright a license. That is something, of course, that the Commission wants to see in the proposals and afterwards also during the implementation. So the original, of course, any creative artistic work, of course, while the right exists automatically, it's you who decides, of course, how you have to be referenced, how, of course, your knowledge, of course, can be used then afterwards and potentially modified. And then we have the trademarks, registered designs, and the trade secrets, which are kind of additional ones, but potentially used more and more actually within Horizon Europe. Now, the trademarks is an identification, basically. Is a distinctive, of course, how something looks like potentially. It could be, what is the famous example? I suppose Google, right? The Google, how, of course, the logo looks like. That is something, of course, distinctively showing the company itself, and that is kind of an easy way to show, of course, what a trademark would be. Registered design, of course, with the Coca-Cola, let's say how the bottle looks like. So it's a shape, it's a color, it's all of these other things as well. This is something, of course, that needs registration. Now, these two can be also used in Horizon Europe. That is potentially less common, I would say, based on all of the projects that we have seen. But the trade secret actually is coming more and more also available within Horizon Europe projects as well. And why? Because this is kind of protecting a specific set of information that has to be confidential. It is not knowledge that is available for the public, and you need to invest, of course, time and effort in order to keep it confidential. And of course, behind then this reasonable effort to keep it a secret, then there is also this protection measure, which is something that is quicker, let's say, to achieve. And you do not need to share, of course, all of the information. And that's why sometimes the patents and the trade secrets kind of decision which one to use, they would normally now go for the trade secrets in many cases, not necessarily for the patents. That could be something, of course, interesting for the research organizations and universities. Okay. Because, of course, that is always a big decision, right? From the technology transfer offices, of course, what to do, what kind of protection measure to use. And sometimes they potentially go for this one as for the others. For the companies, that's definitely something, of course, that they consider carefully. Now, one specific result in your project could be coming with different IP rights. And you could, of course, then use different protection measures as well for the same, right? Or for the parts of the same, of course, result. So if you check, for example, a prototype, then on IP management level, you can decide to patent the data processing itself. Then you can have a copyright on the software that is running the prototype. Also, there could be a copyright on the design. And also then, of course, there could be a trade secret, an in-house kept secret on the overall prototype. Now, all of that, of course, has to be considered, and potentially out of these four, you will be using, let's say, 3 different measures that you want actually to register, attach a license to it, and then, of course, use afterwards for protecting, of course, your prototype. In case we want to extend this a little bit and go towards a little bit more innovation management rather than just IP management, we could consider, of course, that the result is coming with a lot of additional kind of sub-results, or let's call it knowledge and maybe processes and so on. And then we are trying to put together this in a complete package. So it's not only a specific model that we created, a specific methodology, but there could be also additional things attached to that. Because if this methodology potentially is used, it is successfully exploited if you are implementing a specific stakeholder collaboration element next to it. Let's say you want to integrate a new model in a specific region, it only will be successful if you attach a specific participatory approach next to it, which is ensuring the proper validation of the result, which will end up in adoption. So try to think in a way that it's not only potentially one result, but maybe a package of the results, of course, or a package of, again, different procedures that you have to put together in order, again, to successfully exploit that specific result we talk about. So it's coming with the knowledge, it's coming with a stakeholder collaboration method, it's coming maybe with the standardization contribution. And of course, next to it, yes, you could be, of course, publish. You could also, of course, attach a specific license next to the model. So there's IP management part as well, but there's also kind of a full package, of course, how to use all of that. When we talk about the Horizon Europe proposals, we normally consider two specific things. One is the background IP and the other one is the results. Background is an IP, any kind of information, knowledge, of course, intellectual property right that already exists when, of course, the project starts. And that potentially is interesting because giving access to that background IP will be helpful, of course, for the implementation of the project, potentially even helpful or needed, of course, for other partners to exploit their own results. So that's a very specific, of course, IP thing that is needed to be considered at the proposal writing stage and afterwards, of course, to really discuss carefully in the consortium agreement. Results, of course, on the other hand, would be something, an IP that we develop during the project implementation thanks to the project. This, if one partner is putting it together, they will own it. That's easy. If more partners are needed to put together the result, then we end up with the so-called joint ownership. That needs to be discussed in between the joint owners. They should sign the joint ownership agreement. We will talk about this. And then, of course, they will try to make sure that at the proposal writing stage, there are principles that we agreed on. How to manage joint ownership in the first place, how to, of course, handle this specific result, what is needed, of course, to be shared in between the partners in order to put this together, and what happens, of course, after the end of the project. So some of these, of course, key principles will have to be discussed between the partners. SideGround is an interesting thing. That is an IP that is developed during the implementation of the project, but it has nothing to do with the project. Of course, all of the partners would be doing additional research, of course. They will be implementing other projects. They will have, of course, a lot of different internal or even external, of course, research activity. And out of that, there could be interesting IP developed if offered for the project implementation of yours, then you could be creating, of course, an added value. In order to make this happen, you need a so-called IP due diligence procedure. You need to understand what's existing in your institution, what could be offered to anyone, of course, with certain conditions, with certain limitations for the implementation of the project, whether it be background, whether it be sideground. And of course, you need to agree also what happens when potentially the other partners would need, of course, access to your background, sideground, and results after the end of the project for them to successfully exploit their own results. This is an internal discussion. Everyone needs to consider all of these things. For that, you have maybe an IP manager, maybe you have the technology transfer office people, maybe you have a business developer in the institution. Anyone, of course, who has the necessary knowledge about all of these issues could be extremely helpful, and try to involve them at the proposal writing stage so they properly help you, of course, to consider all of your options. Because normally what is needed at the proposal writing stage is to understand, of course, what is that they are bringing to the project, what is that they are contributing to put together, what results the different partners are interested in, what would be their preferable exploitation route, what would be then, of course, the protection measure that they would be then applying if that result is theirs. There is a lot of confusion, actually, who owns what if they jointly contribute to something. It's not necessarily true that you own something just because you helped the development of the specific result. And for that, of course, you need a little bit of legal support. You need a little bit of course, technology transfer support in order to understand what is that we are exchanging, under which conditions, who's the owner, what happens when there's a joint ownership, how are we discussing access rights, and all of these. If you have that, then of course, you potentially at the end in the proposal, you have, of course, an interesting list of expected results, have a plan for the protection. You can have different options as well, of course. And then you have also certain strategies for exploiting the results. It's potentially not a lot of detailed information, of course, for the evaluators. It could be an interesting table that you put together, but the basics need to be there. And that's just important. That's another example, of course, how something can be put together. If you have, let's say, a patent application, you need to understand, of course, who potentially will be interested in buying, of course, the technology and using it. And that could be, let's say, of course, with a time frame also planned 6-12 months post-project. Why? Because normally the first stage of the patent registration is within the project duration. That can be funded. Anything after the end of the project is not. And normally a patent application would take at least 18 months, if not more. Sometimes even years, of course, you have to wait in order to have a patent registered. Licensing, potentially, of course, having a copyright license, that's easy. That's potentially, of course, not a long amount of time, but you may need to wait before you're trying to license it out because you need, let's say, a critical mass of users on a specific platform who will be, of course, satisfied with all of the functionalities, how the platform works, and then they would be potentially happy, of course, to pay for the use of the platform itself afterwards, and so on and so on. So there's a lot of consideration. It's, again, not enough just to have the protection measure. You also have to have a specific plan for exploiting the result with a time frame. What are the next steps? What is possible? How we achieve, of course, that the platform is validated by the users, which will be enabling then, of course, then the adoption of the platform and licensing it out. So all of that, of course, is part of the innovation management. And then as another basic concept, of course, exploitation itself, it's basically the use of the results, right? In any kind of further activities besides, of course, the project itself. And it could be commercial exploitation, of course, with products and procedures and services and so on. And also standardization activities and also, of course, any kind of other exploitation measures. Now, the beneficiaries who have received funding in any of the Horizon Europe projects, they must, for up to 4 years after the end of the action, invest their best effort to exploit the results or directly using them internally, of course, within the institution, somehow integrating it, of course, or exploit it indirectly through transfer or licensing. Licensing, when the ownership remains with you, but you license out, of course, and someone else will be exploiting, or you transfer the result. With that, of course, you transfer the ownership of the result as well. And then again, a third party will be responsible for the exploitation. That best effort obligation has to be taken seriously. The European Commission will be checking up on you for at least 1 year after the end of the project. In Horizon Europe, you have the continuous reporting section on the portal open after the end of the project, and you need to go back and you need to, of course, fill in some additional information, especially on your measures to maximize the impact, including, of course, dissemination, exploitation, and communication measures. So this is something, of course, to consider extremely carefully. Now, it has been true from the very beginning of Horizon Europe that the European Commission wants us to make sure that the knowledge that we generate in these projects can be transformed into so-called useful innovations. The European Commission has set up a so-called valorisation portal to help the beneficiaries to do this properly. And that portal was not the most visited portal ever. I have to admit, it was not extremely user-friendly, but there's a new one. So there is now a new valorization portal that is useful. It also has these codes of practices uploaded. We have a code of practice on the management of intellectual assets. We have a code of practice for standardization, another one for citizen engagement, and also one for the industry-academia collaboration. Now, these are specific codes of practices for institutions. So it's not for you in the research project, of course, to put this together, but it's for the institutions to set up certain procedures, use certain best practices. That could be then, of course, extremely useful because that increases also your innovation capacity, of course, at the end of the day. You could be using these procedures and processes, of course, in the institution to support also the exploitation of your results. And valorization is basically the use of that knowledge and data that you generate for the benefit of the society. That is, of course, what valorization means, and most of our also widening projects that we potentially talk about would be generating that, the knowledge and the data. Of course, different methods, potentially different models, toolkits, guidelines, and so on. And these will be the ones, of course, that again need to be validated and taken up, adopted, of course, by the end users, so that they, of course, start generating those benefits for the target groups. And the policy toolbox is, again, kind of an overall structure, how potentially, of course, an institution or even actually, let's say, regional authority could be putting together soft tools, incentives, financial tools, and maybe regulatory tools as well to support overall the knowledge valorization within the region itself. It's quite useful, of course, to check it out and then potentially spread it a little bit more also within your countries to see, of course, how that could be then adopted also. This is the knowledge valorization platform. I included the link itself, and again, try to check it out. They have good guidelines, they have good best practices that could be also applicable to your project. For the legal considerations, some of the basic stuff, of course, with the grant agreement. Now, when the grant agreement preparation is happening, you definitely should read, of course, the proposal again. What exactly did you promise, of course, in all of the sections of your proposal, especially what regards the 2.2 section? Because based on that, you have to put together a detailed plan for exploiting and disseminating the project results, including communication actions. And in here, you have to be, again, more detailed in terms of which results for you would be key exploitable results. What would happen with them, of course, who owns them? Is it a joint ownership? It is a single ownership? What kind of protection measures would be applicable? What kind of exploitation routes have to be then thought about? And what are the steps that we need to take in order to be successful with that exploitation? Discussing also management structures and procedures for innovation management and some other things as well. The grant agreement has a specific, of course, IP management section, but the more detailed one will be the civil contract amongst all of the partners, which is the consortium agreement. The consortium agreement, of course, cannot be in conflict with the grant agreement itself. The grant agreement would always prevail, but the consortium agreement can be specifying quite a few details. In terms of course, the results, the access rights, what kind of limitations and conditions you set for the background, of course, listed. Right? The background listed, the attachment 1 in the consortium agreement would be then listing all of the IP that you already have and that you potentially, of course, give access to the other partners in order for them to implement the project, or again, in order for them to be able to exploit their own results. For the section 8, the results, of course, the starting point is if a partner is putting together the result on their own, then they will own it. They can basically do whatever they want with that. The joint ownership then requires, of course, a joint agreement in between the partners on all of the details, of course, how they handle the joint ownership. Now, if something is as a result as a scientific methodology, then normally, of course, all of the partners agree that everything will be open. All of these conflicts and problems come in. That's why, of course, an innovation manager will be extremely useful in all of the projects. If the industry and the academia would be putting together the result and they do not agree on these core principles. If you remember, I told you that this is something that you should be agreeing on in the proposal writing phase. If somehow you miss this, then at this point, agreeing on these joint principles potentially will cause you a lot of headaches. because going with open science is one thing, and going with the publication is one thing, and then going with the protection and commercially exploit something, of course, is another thing. The balance and the compromise needs to be somehow then put together if the two partners are not on the same page at this point. So it is important, of course, to agree on this, agree on potentially transferring the results to a third party. How do you do that? What will be then, of course, the procedure? How do you disseminate, of course, all of the results? What kind of conditions and deadlines, of course, will be there for you to stop the process potentially from happening? What kind of access rights you give, or for the implementation, or for the exploitation, or to affiliated entities. So all of these, of course, are key issues in terms of the intellectual property management. So that's from the legal perspective, of course, something that you need to carefully then discuss internally, and then, of course, protecting your interests also include into the consortium agreement. If you have a joint ownership, you should sign a joint ownership agreement. This one will be really clearly saying what is then the distribution of the share. So how we decide on who's owning what out of the jointly owned result. Why do I own 50%? Why do I own, of course, 80% out of the result? Then afterwards, just because I own, let's say, 80%, it doesn't mean that it's my responsibility to protect the result itself. We have to agree on who's doing that, who's covering the costs, and then potentially, of course, what kind of measure we will be going for. Then also, of course, conditions of the use by the joint owners. Again, how to use it in further research, how to use it in individual exploitation, potentially who has right to license it, or even transferring their part of the ownership. So all of these, of course, will be discussed. Applicable law, jurisdiction, and so on, of course, are standard legal, of course, articles within a specific agreement. But no one is telling you, of course, what should be these, but you have to use, of course, your own things that potentially your technology transfer office is, of course, recommending you. For the results, this is based on the DESCA consortium agreement model, of course. And here, normally the organizations would agree on option 1, meaning that if someone wants to use the jointly owned result for internal research or educational purposes, they can. But if they would like to use it for something else, such as commercial, of course, exploitation, they have to give to the other joint owners a notice 45 calendar days in advance, and they have to agree on a fair and reasonable compensation. That is normally, of course, what's included in the consortium agreement, because the option 2 is they don't have to do anything. They do not need any consent. They do not need to inform anyone. They can do whatever with the jointly owned result. That is normally, of course, something that you don't agree with. So you go with option 1. But the key question is what it means fair and reasonable compensation. Because it can be free of charge, of course, that is fair and reasonable for everyone, or one of the partner thinks that it should be free, and the other partner, the other joint owner, thinks that it should be 100,000 euros. You already, of course, see based on that all of these agreements will have potentially a serious legal and financial, of course, consequence. And that's why we need to agree potentially on the principles at the proposal writing phase. So right now, we are not trying to discuss something, of course, with the help of the lawyers, with the help of, I don't know, a mediator, with the help of the coordinator, trying to figure out, of course, what to do and also implement the project itself. And that is why the joint ownership agreement should be signed as soon as you can. Preferably in the very beginning of the project, and do not wait for the result to be available. That may be too late, of course, because if potentially that result is a commercially really valuable result, of course, then more and more conflicts will be coming out of that. Then, of course, access rights. That's also important because we need, of course, access rights or for implementing or then, of course, for exploiting the project results. And then as example, with the background included, of course, you have a lot of different options. Let's say there's a patent that is available and it's free to be used by all of the beneficiaries. There's another one where it is extremely then exclusive, of course, for a certain party to be used, and no one else has access to that. because we know that only beneficiary two will need it for the implementation and the exploitation, no one else. And then we're allowing them to do that. With the database, you can also have limitations and conditions and restrictions. So there could be, of course, a lot of different things that you include into the background, but you need to internally consider, of course, all of these details. For the implementation, normally, of course, you will give royalty-free access because they will need it for the implementation. For the exploitation, if we talk about the result, then it's normally the classic way. If it's internal research and educational purposes, it will be royalty-free. If it's commercial, it will be fair and reasonable conditions. On the other hand, if we want to access to a background, something, of course, that the partner had already when they joined the project, then it's always fair and reasonable condition. And that is something, again, we need to discuss what that means and what exactly, of course, we want to do with our own result and why do we need, of course, access to the background of a partner. It's a really simple example. You have a decision support tool that you come up with, but in order to use that after the end of the project, you will need the data. The data already existed, and it was under the ownership of another partner. If they don't give you the data, the decision support tool will be useless. So that's something, of course, then at the proposal writing stage will have to be agreed on, because it potentially jeopardizes, of course, the exploitation of that result. And then as the last point, the common mistakes. If you do not align, of course, the results with the expected outcomes and the impact pathways, if you do not see the future, what's going to happen with my result, what kind of benefits I will create, then unfortunately you will not have the proper results. If you do not consider carefully open science, then the evaluators will not be fully happy, of course. If it's not aligned, of course, what you plan to do with the research data management practices, then again, you may have an issue also at the evaluation and then also during the implementation. So you need clearly identifying the background. You clearly need to understand what kind of joint ownership issues you potentially have in the project. Make a clear decision if we, of course, protect in any specific way anything and then only after publish, or we potentially follow fully open science approaches and we will share everything and anything, starting with the research methodology, going with all of the data, and of course all of the results as well. And if only the intellectual property rights are considered, if only the protection measures are considered without the wider kind of package and asset management, also you will miss some of the opportunities. That's it for the start IP basics. I stop sharing. And Alicia, I think we need to have a coffee break right now before we go into IP management practices.
That's right. And so we have a break for how many minutes, Gabriela?
Would 10 minutes be good for everyone? We can meet at 3:10.
Good.
Good. All right, see you soon.
So we meet in 10 minutes. Thanks to all. So, hello everyone again, and we hope that you have enjoyed the coffee break. We resume the presentation, and as you can see, okay, the presentation now has a part devoted to AP protection and management in practice, which will be delivered by me of the Spanish Research Council, Alicia Boto. And this part one is devoted to intellectual property protection, patent versus trade secret, searching for novelty, browsing patent, journal, and other databases, role of technology transfer office, timing issues, publish versus protect dilemma, and cost consideration and support schemes. So we start with IP protection, patent versus trade secret. Both options offer IP protection, but in different ways. The patents require total public disclosure, but offer monopoly for up to 20 years. Then competitors can copy it. In examples is the production of drug generics when patents are over. On the contrary, trade secrets are used when it is feared that the patent may be infringed, when competitors may find a roundabout to copy it, or when a permanent monopoly is desired, if the competitors can find an equivalent. A well-known example of trade secrets is Coca-Cola, until Pepsi found out or was given the formula Coca-Cola had a monopoly. When is preferred a patent? Well, it's preferred when the company wants to secure a market space for up to 20 years. If a competitor copies your idea or product, it can be sued. It's preferred when there is the risk that competitors buy your product, analyze it, and figure out how it works. In that case, trade secret is useless. A patent is preferred also when a competitor may patent a similar idea and block you. And also when we want to sell or license our patent. For investors, patents are less risky than trade secrets, which can be disclosed, losing its value. For example, novel drugs, devices, and so on. While a trade secret is preferred when the company is sure that the invention cannot be easily broken down or copied. That's the case of Coca-Cola. The company wants a market exclusivity longer than 20 years, or the invention does not meet some patent criteria, such as novelty, being non-obvious, and so on. Also, when the company wants to avoid high cost, we must not forget that a patent is expensive and legal processes in infringement cases are expensive as well. Examples of trade secrets is Coca-Cola, Google, and other search algorithms, and so on. When we search for novelty, we should carry out a preliminary search in different databases. For instance, general patent and journal databases such as SciFinder, Reaxys, PubMed, or the ones in journal editorials. There are also exclusive patent databases such as SpaceNet, Use Patents, Google Patents, and so on. Artificial intelligence tools are also very useful, such as Gemini, ChatGPT, Grok, and so on. But be careful with artificial intelligence tools. Always verify and do not upload your results. Only post general questions. In examples of journal databases is this one, Nature Communication. As we can see on the top right, there is a search tool in which we can write a term. For instance, CRISPR. And then with the search button, we obtain many different results in this database. Another example is SpaceNet, which is a specialized patent database. As we can see on the left, there are three different types of search. One is faster, another advanced search is more complete. My favorite is advanced search. You can choose from different collections, for instance, worldwide, use patents, European patents, and so on. And if you have more data, for instance, the title of the patents or part of the contents of the abstract or publication number, priority number, and so on, the search can be even faster. Another very useful database is Google Patents, because it can be combined with non-patent literature, that is the Google Scholar database. And in this way, we can have patents, journals, and other publications. For instance, in this case, we write CRISPR in the Google patents and will give us a lot of patents, but will also give us different journal publications which are relevant to our area. Well, once this preliminary search is over, and since to confirm a novelty, the researchers must contact local knowledge transfer office or technology transfer office, because they can carry out comprehensive patentability studies. In the case of companies, and also academy, IP agencies can conduct commercial and patentability studies that provide a vision of the novelty of the approach and possible competence in the market. The patentability reports that TTOs or agencies prepare usually contain report objectives, database search strategies such as keywords, browse databases, and so on, analysis of result, is there novelty, conclusion, whether to proceed with the patent or not, general observation, a list of the reference, and a summary. Well, TTOs can guide the researcher or the entity through the patenting process. A patent process is long and costly, but we must have one thing into account. In universities, research organisms, and so on, the TTO pays, not the researchers. So, when we file a patent, month 0, a process starts in which, in the first 12 months, we have time to complete our results, our experiments, and so on. Then we have the file of the PCT. This is the international phase, the beginning of the international phase. We have different processes in this time, for instance, examining this preliminary patent by different experts and so on, modifications, and many other arrangements. Now, on month 30, starts the PCT national phase, in which we file for patents in different countries or in different regions. For instance, the European Union, you don't have to file for England, France, Germany, and so on. There is a unified patent for Europe. In any case, the different countries can accept, reject, or ask to modify this country application, this particular application. So it's a long and expensive process in this area, in this phase. Well, we can see that here, when the first filing is made, the researcher can publish and disseminate. As we said, in the first 12 months, there is a period which can be used to collect new evidence and reinforce the PCT application. This cannot be done on later phases unless we add the patent to the patent tree. And now we have the most complicated phase. The first application is usually made through the patent office of each country, and it's often in the native language. But when you go to the PCT and so on, you generally use another language, generally English, but you can use many other languages. For instance, in the EP, you can use French, German, and so on. In this case, as you can see on the right, the first filing is the priority date, and then there is a patent tree consisting of patents derived from the original and the PCT. Now we go to the following subject, the timing issues, publish versus protect dilemma. For instance, the researcher finds that one has a result with commercial interest and addresses the TTO. What should I do? The TTO says, first, pause dissemination because any leak disclosure can destroy protection. And the researcher may say, but I have a paper almost finished, and I need to increase my curriculum vitae for a job selection process. The TTO must find solutions to this. For instance, use white papers and write about what the results achieves, but not the procedure, not how it is done until we study your case. Besides, an express patenting process can take 1 or 2 months, and the moment you file, you can publish, and you will have a valuable patent and paper for your curriculum vitae, for your CV. Well, a PhD thesis is a particular case of publication. In this case, the student has a deadline for presenting the defense. In that case, the TTO can present a solution, for instance, negotiating a closed defense. And the examiners can sign a non-disclosure agreement, an NDA. We move to another consideration, cost considerations, and the support schemes. As we said, a patent process is long and costly. When the first filing is made, as we can see at the bottom of the slide, we are still in an affordable stage. In some cases, the entity, if it's an academic entity, does not have to pay anything, or it has to pay very little because it's covered by some entities. But when you file for a PCT, the expenses grow. This stage is relatively expensive. But when we move to the national phases, it's very, very expensive stage, thousands and thousands of euros. Furthermore, the longer the patent is maintained, the more expensive the annual fee will be. Now we have a summary of patent cost. First, the pre-filing stage. If you don't have a TTO that covers this stage, one must hire a patent agency for the patentability study to polish the application and, very important, the claims. Now, we have the filing and examination fees. Besides the initial filing payment, most times an application should be modified during the examination process. With each modification made by a professional attorney, the cost sum up. Then we have issue fees. Once the patent is accepted, one must pay. Expensive, but the worst is the maintenance fees because they increase considerably each year. Now, we have a tip. Use the low-cost provisional patent application the first 12 months to find investor, partners, potential clients, namely test the market. Well, it helps decide whether it's worthwhile to invest large sums in PCT and national phase application. If you find investor, partners, and so on, proceed with the last stages. If not, rethink your strategy. As we say, a patent process is long and costly, but the European Union can give additional help. For instance, the European IP Help Desk provides free advice on IP strategy and patentability. Here is the link to this useful help desk. As we can read, provides free of charge support to help European small and medium enterprises and beneficiaries of a funded research project to manage their intellectual property in the context of transnational business and innovation programs. And another very useful platform is this UIPO, which has a program which is SME Fund, which is aimed to small and medium enterprises and which is very useful to fund their patents and cost in other forms of intellectual property protection. So please visit these two pages and also the pages of your national agencies because they usually periodically issue some very interesting calls to cover these costs. And this is all for my part. And then I give the floor to Gabriela again because she is commenting the second part of this talk. Thanks, Gabriela.
Yes, okay. Thank you very much. Alicia, I have to admit that we are behind schedule. So I can finish the presentation, but probably we will not have time for the Mentimeter. Just for everyone to kind of know that in advance. Because it's going to be another 20 minutes and I don't think that we can manage that. Really sorry for that. I think I was longer than expected.
Okay, it's perhaps the coffee break should have been shorter.
No,
but in any case,
I think it's fine.
In any case, don't worry because we have a 15-minute margin, so don't worry about this. Oh, please go on.
All right. So then in the second part, we are trying to put together some practical kind of procedures and tools, of course, that you will use for the IP management itself. Then, yeah, let's see if the Mentimeter can fit here or not. Now, as a starting point, of course, one of the obligations for us when we do the reporting, so during the implementation of the project, under the continuous reporting section on the funding attendance portal, we have to upload all of our results, right, for the European Commission. And then if you check how the reporting template looks like, of course, that can be downloaded in a PDF, and then you will see that when you give the type of the result, you have several options. You can talk about the scientific discovery or model theory. You can put together a product or a service or a process. You can create a business model, design a method, the policy recommendations or guidance, a specific event, could be an important workshop, of course, or conference and so on. If you potentially, of course, train anyone within the project, such as staff, then of course you can also have qualified personnel as an important result. Also the learning and teaching materials and potentially any new infrastructure. These are kind of the key types of the results that you could upload on the portal. And that may be important for you, of course, when you put together the proposal as well, like what exactly you want to promise. On the right side with the bullet points, you see, of course, all of these options. And then again, consider this, what kind of results you will be, of course, developing again for which kind of users, of course, and who will be the target groups, of course, the beneficiaries who will be, of course, potentially benefiting from the use of that result. And then, of course, out of that key result could be, of course, delivering a high scientific potential, a high societal potential, other than environmental or an environmental one, of course, technological, business, economic, or, of course, a policy. And again, whenever you upload a result, you will have to select to that, of course, this kind of high potential impact area. You need to describe then why you think that it can generate this high potential scientific, of course, impact itself. Who will be the key target groups, of course, who will be the main beneficiaries. Then what are the steps that you have already undertaken to support the use of the results? Will it be, of course, going higher on the TRL level? So you have prototyping in production, in laboratory, and so on. You demonstrated it, you tested it. You already, of course, taking care of the intellectual property protection measures, let's say. Then you already complying with the regulatory framework, you contribute to standard, you already developed the feasibility study or the market study and the business plan, or you did anything else. And again, if you check all of these steps, it is not only, of course, about IP protection, but again, there could be several additional steps, of course, that ensure that the exploitation is happening. And depending what kind of result you have, you may have to also report to the Commission about the market maturity. Would it be something which is not existing yet and you create a market demand, or towards the end of course, you already compete with everyone else because there are a lot of additional kind of similar solutions also on the market and you want to kind of enter a full competition. We then, of course, need to make sure that we are able to give, of course, a proper kind of justification on all of this. And for that, we need to understand, of course, a few things, such as we need to, of course, capture and then manage, of course, all of these research results. There has to be someone responsible, of course, in order to put together, of course, these management frameworks and procedures, trying to establish, of course, a good guiding material for all of the partners, how to handle, what to do, of course. That could be also coming from your specific policies from the institution that you can use also in the project. And then based on that, of course, you come up with a good protection strategy and procedure. But then also with the exploitation of the result, of course, we need to capture the result. We need to understand, of course. We need to see what kind of opportunities this result brings. Again, as I said, full kind of package potentially. Then trying to put up the exploitation strategies, and then, of course, afterwards, doing the dissemination communication. An overall picture, okay, let's not forget that the intellectual asset management will identify, will evaluate the potential, then will, of course, support the protection, the exploitation, and afterwards, of course, the disclosure. We need to make sure that it's not enough to have an invention, to have a specific result. That will only follow up the process from the idea to the implementation. But we also need to show that something works. We validate, of course, it completely. And afterwards, we make it ready, of course, for the adoption. And that could be also market readiness level. It could be also manufacturing readiness level. It can be business readiness level. It can be societal readiness level. It doesn't really matter what kind of scheme you use, of course. The point would be that the result is validated and then used, adopted. And if we go to very specifically the IP management basics, of course, then we have 6 pillars of IP management. First, we have to understand the background. So what really is the IP that is used? Then what is, of course, the result that we created? What kind of IP, of course, could be linked to that? We assess, we evaluate, of course. Then we decide on the protection, how, of course, this potentially supports commercial or non-commercial exploitation. When the protection is done, we do, of course, the specific activities for the dissemination exploitation, and then we are not done. We also need to make sure that we fulfill all of the legal obligations also after the end of the project. So there is also a post-project management pillar here. As a starting point, the creation, right? We need to capture the result. There could be different ways, of course, doing that. One of the easiest things and the simplest is to use the so-called IP note. Here, basically what you do is that whenever there's a result put together in the project, it doesn't have to be a deliverable, just a result, of course, available. Then you need to fill this in, and you need to, of course, notify the proper management, of course, structure and the people within in order for them to understand what is the result, of course, that has been developed, what is behind, of course, who contributed to that, what are the options for protection, what potentially exploitation plans you have. And then afterwards, they can, of course, give their specific recommendations. Again, it's not necessarily true that all of the partners understand everything about intellectual property management and exploitation. So there could be, of course, then a specific structure in the project who's helping, of course, everyone to try to do this in a proper way. So you give a summary, you, of course, give a description on how the partners contributed, what potentially, of course, could be the principle on sharing, the ownership, what could be, of course, the exploitation potential, what kind of protection you imagine, and then, of course, this will be received by the specific management structure. They will be giving some recommendations and conclusions, and there could be, of course, a follow-up. It's not just one IP note filled in, but then it has to go back and forth to see, of course, if the actions that were proposed were taken, if there is any change potentially that needs to be made. So that could be one of the simplest forms. Another one could be the so-called KER tracking. So tracking, of course, the key exploitable results. You give a very detailed guidance to all of the partners, trying, of course, to them also give some kind of an instruction how to describe potentially the result, how to explain the background, what kind of considerations, of course, could be analyzed, let's say, by all of the partners contributing. And then you could then create, of course, an exploitation plan with specific actions. So what has to be done, of course? What could be done for protection? What could be done for development, testing, validation, deployment, all of those additional steps? Discuss, of course, the ownership, and potentially afterwards, when all this is done, of course, trying also to disseminate so that, of course, all of these actions will support the exploitation. And then, of course, there is this assessment template that helps all of the partners to try to do this. The assessment and the evaluation, of course, is a really important step because we need to understand the potential, of course. For that, we need to understand the available, of course, the state of the art in terms of what technologies exist. Do we have to consider anything else? What kind of competitors are out there in the scientific or in the industry field, of course? Analyzing, of course, what are the trends? Potentially, of course, doing the cost-benefit analysis. Not everyone needs to understand, of course, how this is done. That is why you need, of course, in the consortium, someone, if this is relevant, of course, who can assess the technology and the market and trying to give, of course, for you some kind of a description on the potential, of course, of that idea. And part of that, of course, as Alicia showed, indeed, you have to search for patents. You potentially have to differentiate, of course, between patents and then trade secret. You have to see which one is the best for you. You potentially have to search for standards. You may have to decide if you contribute to an existing one, validate an existing one, potentially create a new one. There could be a lot of elements, of course. Again, one result is not only, of course, one specific IP right, but there could be different ones. Try to imagine, of course, the whole package again. Then you decide on the protection. It is your legal obligation, of course, to do the protection. If it's a jointly owned result, then you have to decide who is responsible, who will be covering all of those costs, potentially you share, of course, and then you have to agree on the specific way to go forward. You have, of course, options, and then you have to decide which one to go for. When you put together, of course, the proposal, you have a short kind of strategy for exploiting the results. Then by month 6, there is an official deliverable that you need to submit to the European Commission, which is then the detailed plan for disseminating and exploiting the project results. And normally towards the end of the project, you have a so-called final exploitation plan, or even, of course, final business plan, depending on, of course, what kind of exploitation routes you have planned with. So if you put together, of course, the final exploitation plan, you have to describe a few things. Of course, you introduce all of the key exploitable results. You show, of course, who are the key stakeholders, how you, of course, manage the ownership, what kind of IP management you have decided on, what kind of exploitation routes, how you get yourself ready, of course, for the market. You analyze the risks. Then you try to show, of course, how can you contribute to the different impact pathways as well, and how you're trying to ensuring the long-term sustainability. And all of that can be a really complicated process depending on a lot of stuff, such as, what is my latest example, an expert network. An expert network was put together in one of the projects, and we need to make sure that there is, of course, a final exploitation plan. So how on earth we keep together the experts who will be potentially, of course, coordinating the collaboration in between the experts, how the experts can support the different clients, would it be the European Commission, would it be a ministry, would it be a major company, let's say, who needs advice on a specific issue. We need to kind of consider, okay, organizational wise, of course, who, how, which institutional commitment, of course, then what the experts need, of course, to stay within. Would it be recognition? Would it be financial compensation? How can we ensure that? What makes it, of course, sustainable? We need, of course, the need from the clients so that, of course, they show that they need all of these experts and they are willing to pay, of course, for the services in the future. So it doesn't have to be an exact technology, of course, that you protect with a patent or with a trade secret, and then you move on, of course, to the market, commercially exploit it and generate a lot of profit. The point of the exploitation, and again, the overall picture, is to try to understand, of course, that one key thing, that is the result of a need, right? Because there was a need, of course, for the expert knowledge to come into the project, and that expert knowledge is needed, of course, by these specific clients. Then how to make sure, of course, that it will be also then available after the end of the project and it will be used. If it is helpful, and we normally actually use that, and it is helpful for us, we normally go on Cordis and we try to look for something similar that we need also ourselves. There are a lot of different exploitation plans, of course, not necessarily the full one, of course, because there are always confidential parts in the exploitation plans. But if, of course, you see the overall kind of considerations, what kind of options maybe they have considered based on which they have selected the specific exploitation route, then you can see, of course, a lot of interesting ones within your own scientific field, how they solve this, how they solve that. And again, it's not about just the result itself and what will be the intellectual property protection method, but also what kind of actions they need to make it happen. What kind of collaborations and partnerships they need to establish, what kind of a market assessment and validation they need, how they potentially ensure the financial sustainability with funding or any kind of additional financing. So all of the benchmarking exercise, of course, is useful to see, okay, if someone already managed to sustain an expert network after the end of the project, then maybe let's look into, of course, the exploitation plan to see what we have to make sure, of course, that it's happening for us to be successful with it. And the business plan, of course, it's something extremely specific, right? With a commercial, of course, valued result. Here, you are very specifically making a detailed market analysis. You create a value proposition. You have a go-to-market strategy with a really clear timeline. You have a business model that, of course, shows the revenues and the cost structure. You can use a business model canvas that is the simplest way, but of course, at this stage, it has to be extremely specific. Then you have really clear numbers, financial projections. you will analyze the regulatory and the legal compliance, what exactly we have to do, of course, again, to make it happen. It's not enough to have a business plan. We need, of course, to make sure that we fulfill all of the regulatory, legal, and other conditions. And we need a team, we need the skills, we potentially need a lot of other stuff as well, of course, to make this happen. Normally, again, several parts of this is confidential, but some examples, again, from the previous projects can also be found on Cordis, which could be helpful again. So I'm kind of encouraging you to look a little bit. It takes time, of course, to find something useful, but still, of course, it is a good benchmark exercise. And then at the end of the project, or more specifically after the end of the project, we need to fulfill, right, certain obligations. At the end of the project, we will submit the so-called final plan for disseminating and exploiting the project results, or final report also. And in this one, we will make certain commitments. What's going to happen after the end of the project? Now, yes, we have the 4 years for the exploiting the result, but also, if in this plan we are promising something that should be happening, and unfortunately we fail, because despite our best efforts, the results are not exploited within 1 year after the end of the action, then the beneficiaries can be obliged to upload their results to the so-called Horizon Results platform. Because the Horizon Results platform should be helping you to show your result and then find ways to exploit it, because you want influence policy, or because you need corporate financing, you need business planning advice, you need further technological advancement in order for that result to be exploitable. There could be a lot of ways, of course, and then the Horizon Results platform would be trying to help you to get connected with the necessary, of course, collaborator who can be helpful with the exploitation of the result. If for any specific reason you did not promise something to be happening 1 year after the end of the project, but you promised 3 years, then the Commission will not force you, of course, to publish these results on the platform. But of course, without sharing confidential information, you can still look, of course, for necessary collaborators, or you can look, of course, for financing and so on. If it is an innovation, a specific technology, something extremely interesting, then you could go rather to the innovation radar. There, the experts will be analyzing if you are market ready, you are business ready, you are technology ready, or you need all of these steps to actually have that innovation potential met. And then it will be a better way kind of to share any kind of innovative result, because of the analysis, and because, of course, then the investors, when they see something is business ready, they definitely go to the innovation radar and they will check those results. The Horizon Results platform at this point is a huge database. I think the Commission even would like to change the search function, and it will be a lot more user-friendly in the future. For now, it is a lot more working as a dissemination platform rather than an exploitation platform. And then, again, under the continuous reporting, there will be a new tab opening up at the end of the project, which is so-called Result Ownership List. And here, you will have to list all of your results, but from a different perspective than what I introduced at the beginning of the presentation. Here you will have to kind of list the result and then say if this is under single ownership or joint ownership. Then you have to list the owners. You have to include their PIC number, who's owning it. Then also, will the owners exploit the result, yes or no? If you're not, of course, because that's allowed, right, indirectly then exploit the result, you will have to explain what's going to happen. Then, if relevant, in which form the result will be made available to the other consortium members, because again, if you remember, decision support tool that needs the database, you can describe here then the database will be available for this company based on fair and reasonable compensation conditions, let's say. Then, does the exploitation of the results require access to background of one or several of the consortium members? Yes, no. If yes, then which one? How, of course. And then, would the exploitation of the results require access to third-party IPR? Maybe you need to buy a license, let's say. And of course, yes, no, or you don't know. Now, you do not need to have all of the answers at the very end of the project, but that is one table that you definitely need to fill in fully, within 1 year after the end of the project. You need to figure out, of course, the answers to all of these. That is kind of a novelty within Horizon Europe, and the first projects that are finishing, they have to already fill in this specific table. Of course, the European Commission understands that this is not easy, and they are trying to help you as much, of course, that they can. They have the Horizon Results Platform. They have the IP Helpdesk that Alicia talked about. I talked about the Innovation Radar and also the Knowledge Valorization Platform. These are some basic things, of course, that the European Commission has. And then you already know the widerAdvance facility, of course, for the widening countries. The booster is also existing, of course, for dissemination, go-to-market, and ads and services support, of course, and they can give you potentially also specific IP advice as well, so how to protect, how to exploit. And then also the Horizon Standardization Booster is back. It is available again. And then potentially you could even have, not necessarily even for a basic fee, but then also with no cost, support to the standardization itself. So check out these websites. They can give you, of course, really useful support services and advice. That's it. Any questions?
There are okay.
Yes, we have a question.
I'm sorry, Vasiliki, I did not hear you.
Yes, we have a question from Vasiliki Theodorou.
Right, yeah.
Yes, Vasiliki, can you please open your microphone? Thank you.
Hear me?
Yes.
Can you hear me now?
Yeah.
Okay, cool. Thank you for the presentations. Very nice as always. I have a question. I am co-coordinating and also managing the grant, okay? But what you have presented here, you need one dedicated person doing only this part, right? So even for a dedicated manager, I think this is a lot of work in order to keep up with all this information.
That is a yes and no. Depending on the project that you're working on, it's not necessarily a huge amount of work that we talked about. An innovation manager or a technology transfer office person could be checking up on your project every, 3-6 months, and they could be within 1 hour giving you extremely useful advice what to do and how to do. And afterwards, the partners, of course, are still responsible for the exploitation itself. So you do not need, of course, a lot of time to be allocated, but you need the knowledge, the experience behind, of course, that can give you that specific set of, action set advice that you need to implement. So it's not necessarily a huge amount of effort. In other cases, of course, when you imagine a project which is kind of about, of course, all of these innovations to go with a extremely high technological readiness level and being available, of course, then from the very beginning, in the proposal, you have to plan with a lot of additional activity, putting together the market assessment, putting together then, of course, then the business plan, doing some kind of a marketing planning as well, because the higher the TRL level that you promise in the proposal, the more specific activities, of course, you will plan in the work package that should be financed. And part of that, of course, will be the availability of an innovation manager as well. It could be one person, it could be different people actually working in a small board within the consortium. Again, depends, of course, how complex system you need.
Mm-hmm. And if in the grant, for example, thank God we were not that promising. We have only 2 cares identified in the grant, and these are the ones that we are following up. Is it wise to add additional cares as the project evolves? Or
if you have new ones and you know that it's going to be extremely beneficial for your target groups, then absolutely, of course, add it, because sometimes even the non-expected result, of course, could be extremely good. And it could create an added value, and also the commission, of course, loves that very much.
So, for example, as you said, the organization of a workshop, the training, the staff training, some facilities that might be working, are these considered key exploitable results and should be included?
It could be, right? So it depends. The stuff actually, as a result, specifically in the continuous reporting, is mostly for, specific actions like Marie Curie's, right? This is, of course, one of the core things that you will put together. But in other cases, when you have a standard research projects, but you can actually integrate an activity in science education, would it be for the master students? Would it be for early stage researchers and so on? That could be also, of course, extremely useful. The question is, do you have the budget for that?
Yeah, the twinnings have a lot of administration and supportive offices training, right?
If you can allow the project to do this, of course, then there could be, of course, an additional interesting result that you deliver within the project. If you don't have the budget for that, unfortunately, you can be extremely creative with additional results.
So we should add it in this table of
you
the
could,
results
you
table.
could, yeah,
you can
you
add
could.
all of these, all the training, all the visits. Okay.
You could, yeah, absolutely. But of course, you need to think about then how it is useful afterwards. It's not only that you had one interesting workshop, and of course, there will be the staff trained, but the question is how this staff trained will be then, of course, afterwards generating additional benefits, because the main perspective is if you train them on a very specific nanotechnology procedure, then they should go back to the research institution and actually, of course, then use it.
Yeah.
So it's, again, one of the key questions, right? How the results will be then generating impact.
Oh, that's perfect. No, we've done that. Okay, cool. Thank you very much.
You're welcome.
I would like to add one thing for the experienced managers. There are specialized tools, informatic tools, to help them in the OTT or as themselves in a company. If you go to the previous presentation of IP protection versus dissemination, you will see that informatic tools such as Wellspring, Intune, Questel, Triangle IP, Innoloft, or Airtable can help you a lot through all this protection process. And that's all.
Okay, thank you.
Any other question? Our speakers are more than happy to answer. In the meantime, would it be possible, Alicia, to put to share a link for the feedback survey, please? In the meantime, just to let you know that in the following 2 days, the attendees will receive the presentation shared today, as well as a link to the recording. So if for technical reasons we are not able to share the feedback survey, we will share with the presentations. So it would be great if you could respond to our feedback survey upon receiving the presentation, if technically it's not possible to share the link today. Okay. Yes. Please use the QR code or the link to give us your feedback. Take a couple of 2 or 3 minutes, the most. We would be very, very grateful. Alicia, can you please put the link in the chat as well? Thank you. Those of you who are here, 19 persons or a little bit less, please fill in this feedback survey. It is a very few minutes of your time, but your input is very precious to us. Additionally, we will be asking you, for those who will not complete the survey today, to do it upon reception of the presentations. So 1 minute before we close, and all the speakers, Gabriela, Alicia, and me, would like to thank you very much for taking the time to be with us and really see what we have to share about IP management and practical cases. We hope to see you all in next services, as well as to see those of you who are not members of the widerAdvance facility to meet at another time in your capacity as beneficiaries of the facility. If you need any help, don't hesitate to reach out to info@widerAdvance.eu or visit our webpage and find the relevant contact person for your country for more information. Thank you very much and have a lovely afternoon. Bye-bye.
Bye, everyone.